GCAAR forms updates in the most recent batch that have been released, as well as the batch that were released last fall. And if we've got time to talk about some other topics, we'll talk about that too.
Sounds great.
So let's go ahead. And so Noah, you want to take it away?
Yeah, good morning, everyone. I'm Noah Cantor. I'm one of the attorneys with KBS Title. I work mainly out of our Bethesda office, but I'm around in Virginia in our DC offices as well. So hope to meet many of you. So yeah, we're going to talk about the GCAAR forms updates. We actually just came out with updates that are being released today. As Dan knows, we're working on some big things in the committee. Unfortunately, we didn't get some of those done for the release today. Those will probably come out in the July release. So looking forward to some big updates coming in GCAAR forms in July. We'll talk about the updates we did get done for today's release, and then go back, just make sure you're familiar with recent updates in GCAAR forms as well, and then just bring up a few points surrounding the updates in the forms that we're going to be talking about, just reminders on those forms. Okay, so let's get started. First update came out today with GCAAR, and that is in Form 900. That's the REA addendum for those that are familiar with that from Montgomery County. We have a new paragraph that was added, and it's for carbon monoxide. It's right under the smoke detector requirement paragraph. Paragraph 2 is smoke detectors. Now, new paragraph 3 is carbon monoxide detectors. Montgomery County requires those, so it lays out the requirements. I'll just read those to you just so you get a sense of what's going to be required for Montgomery County properties, carbon monoxide detectors. Paragraph now states, Montgomery County requires the owner of each occupied single unit, 2-unit, and townhouse dwelling. Okay, so single units, duplexes, and townhouses, not condo buildings, containing a fuel burning appliance or attached garage. So if they don't have a fuel burning appliance or an attached garage, it wouldn't apply even on a single family or townhouse. It requires those units to have carbon monoxide detection and warning equipment. Carbon monoxide alarms or detectors must be installed, and it says here's where they have to be installed. 1 outside of each separate dwelling unit sleeping area and in the immediate vicinity of the bedrooms, and on every occupied level of a dwelling unit, including basements. So outside bedrooms and on every level for the requirements for where the carbon monoxide detectors must be placed, and also must be located on the wall, ceiling, or other location as specified in the manufacturer's published instructions that accompany the unit. Okay, and then there's a citation to the specific Montgomery County Code section and a link in the REA addendum. So right in the document, it can take you to a link laying out the statutory requirements for carbon monoxide detectors. Same ideas for smoke detectors, it just now added carbon monoxide. Okay. Dan's going to let one more person in the office. Nothing to add on that, right? Moving on from carbon monoxide. Okay. Moving on. Some other recent updates with GCAAR. We recently added an HPAP home sales contract addendum, so a specific addendum related to HPAP. That's the DC loan grant program that has to do with exemption from transfer taxes, other benefits. I believe you may not see much, if you do business in DC, you may not be seeing much HPAP this year. I think they're already full for the year, actually. Yep. So may not see much, but just something to be aware of. Keep in mind, if you do have an HPAP transaction, that there is a required HPAP addendum, and it specifies mainly the inspection requirements that DC has surrounding HPAP.
Yeah, and I think what Noah's alluding to there is the fact that HPAP has run out of money for this fiscal year. So I'm not sure if that's October that it gets refunded, but that's for the year that they're out of funds.
Right, for the tax year. So it's at least through September. I think they do it on the tax year. Yeah. So at least through the end of September. Okay, and that's on HPAP. Another recent update has to do with the increase in Montgomery County recordation tax. There was Montgomery County recordation tax increase that went through a few months back. So the seller net sheets have been updated in buyer estimated costs in the GCAAR library, so you could do that. If you have one through Remax, I'm not sure if that's been updated as well for Montgomery County recordation taxes. You could always use, we have a closing cost calculator through our website, through KBS website, that has been updated to reflect the Montgomery County recordation tax increase. So there's a few options there, but it has been updated in GCAAR's library. Just to give you a sense, I mean, this has already been in place a few months, but it's on a sliding scale, the recordation tax increase. Up to 600,000, there is no change. Up to 600,000, there's no change in the recordation tax in Montgomery County. And then it's a sliding scale going up as the sales price increases. Just to give you an example, and we have actually a chart that covers this. If you're interested in seeing that, myself or Ashley can pass that on to you. But we have a chart covering some different sales prices and what the recordation tax increase would be, just to give you a sense. If you go to 700,000, you're looking at about a $700 increase in recordation tax. And that's on both sides, on the buyer and seller side, since they're split equally. Go up to 900,000, you're looking at about a $2,000 increase. So it gets larger as you go up. $1,250,000, you're looking at almost $6,000 increase on recordation tax. $3 million property, it's not even mentioned that. $3 million property, you're looking at about an $18,000 increase in recordation tax. So no joke as you go up in price.
Anybody have any questions so far on that stuff?
Hey, Dan, sorry, it's Kevin. I just signed in. When did that take effect on the increase?
October.
Oh, this October.
Last October. It's already in effect.
2023.
And the numbers you mentioned, like up to the $700 increase at 700, is that then divided by 50%?
That's on each side. Buyer
Oh, that's on each side. So it is pretty huge. Okay.
Yeah, it's a decent increase. Yep. Okay. So that's the increase in record. Any other questions on that? Okay. Another minor update, but just want to mention the form anyway. GCAAR updated the potential adverse consequence acknowledgement. Just some minor language changes that we made in there that don't really have much effect on you, but it is an opportunity to mention that you should be using that potential adverse consequences acknowledgement. There's a similar form for NVAR. GCAAR has one as well. If your buyer is waiving contingencies or not inspecting the property, not seeing the property before purchasing, you can check off an initial certain acknowledgements of adverse consequences. And that's pretty important to have your buyers do that if they're waiving contingencies.
And just to piggyback on what Noah just said on that, for those of you, some of you may have already noticed that in the compliance review, I'm increasingly becoming more vigilant on that aspect. And we're moving towards making it a requirement to require that form if your buyer is not going to have those inspections. So can you describe, Noah, what's the purpose of that form?
Sure.
Specifically, what's the purpose for it and why it's so important?
Yeah, so it really partially protects you in the transaction to make sure that you, as the realtor, as the agent, are making sure that your clients are acknowledging the fact that they're taking certain risks in the transaction, if they're waiving contingencies, and making sure, obviously, the buyer understands the risks they're waiving if they're waiving certain contingencies. So you definitely want to have the buyer acknowledge that.
Yeah, and so the reason why we're moving towards making it a stronger requirement in the checklist is because we want to protect you as the individual agent, as well as protecting the brokerage from litigation. And when we include the form, we're drawing to the buyer's attention that they have the opportunity to have these things, but they've waived them in order to be competitive. And but we've informed them that they have the right to have these inspections. So that's the key part, and this is simply to protect the brokerage and our own licenses individually as agents. Anybody have questions on that?
Hey, Dan, I don't have a question, but I think an observation. I just pulled up the Maryland form, and I'm pretty sure on the NVAR it doesn't say offer price higher than the listed price. That jumped out at me because you think that's obvious, right? But On the Maryland, on the GCAAR forms, it says offer price higher than the listed price. On NVAR, I'm not sure that's there, so maybe that would be something we tell NVAR to add,
Yeah, I
you
think,
know, or compare the two at least, right?
yeah, yeah. And I think, Marty is on NVAR forms, isn't he?
He's Andrew from our office.
Andrew is,
Yeah.
okay, so maybe we could, piggyback that. too.
Yeah, I can mention it to Andrew.
Yeah.
Andrew's another.
I might be wrong, but it jumped out on me on Maryland, and it never jumped out on me on the NVAR stuff. So maybe they added it, but
Now that you mention it, I think you are right, Kevin.
No, it's a good point. I'll bring it up to Andrew, who's one of the other attorneys in our office who's on NVAR forms.
Good deal.
Very good. All right. A few other updates to mention, recent GCAAR updates. Another one was in DC, the jurisdictional disclosure and addendum for DC. We added a disclosure and requirement on heritage trees. There's now statutory heritage tree requirement. Seller must disclose in paragraph 2 of the DC jurisdictional addendum whether there is or is not a heritage tree on the property. What's a heritage tree? A tree with a circumference of 100 inches or more. How do you determine if there's a heritage tree on the property? DC has a website that you can go to, which includes an interactive map. I can send you the link if you need it. If you Google DC heritage trees, it should pull it up, the website, or we can email you the link to it. But it includes an interactive map where you can plug in the address of the property, and it will actually tell you if there's a possible heritage tree on the property. Sometimes it'll be clear that there is one. Sometimes it'll be clear that there is not. Sometimes it'll be close because it's not updated in real time. But if it's close to that 100-inch mark, it'll note that it's possible. And then you may have to contact DC to get an arborist out there to confirm whether it's a heritage tree. But there's pretty hefty fines for removing heritage trees. So obviously, if the seller does not disclose the fact that there's a heritage tree, buyer, which they shouldn't do anyway, but buyer then removes a heritage tree, gets a hefty fine that could come back on the seller. So that's something you want to be aware of.
And also what the heritage tree provision does talk about in the website is that there is a buffer area of ground surrounding that heritage tree that prevents construction or any kind of disturbing of the ground surrounding that. And the website goes in depth and it describes what that buffer zone is. So you can't disturb the area around that tree because you could be disturbing those roots and you're causing it to die anyways. So there's some serious penalties for this, and you need to be aware of it. So when you're listing properties in DC or selling properties in DC, look on the property to see if you've got a tree or trees that have got a circumference that could potentially come close to that 100-inch diameter, and then and work with that. Anybody have questions on that?
Questions on heritage trees?
And so the addition of this provision in the jurisdictional addendum eliminated what was tied to the elimination of the soil types. So in the past, we used to have to state what the soil type was. That has now gone away. And so that's no longer an issue in the resale.
Exactly. It replaced that requirement.
It's in the same spot that soil was in before. So it was number 2, I think.
Yep. Paragraph 2.
Yep.
Cool. Okay. Another recent change was to the Montgomery County jurisdictional addendum, and this covers Montgomery County transfer recordation taxes. I'll mention the change real quick and take this opportunity, since we're talking about transfer recordation taxes in Montgomery County in Maryland. For those that don't do a ton of business in Maryland and Montgomery County, or even if you do, I get a ton of questions all the time on transfer recordation taxes, the split of transfer recordation taxes in Maryland. So just want to go over that paragraph. The language is confusing. We've addressed it a couple times, but I don't know that there's a good way to not make it confusing just because of the way the statute is set up. But I'll go through that, make sure we all understand that. The change had to do with actually a change that MR made, that Maryland Realtors made. They actually added language in their contract that stated when the buyer is going to use the property as a principal residence, they get the full benefit of the state recordation tax credit off of the recordation tax for being a principal residence. That's not the case. That's not our practice generally in Montgomery County. In GCAAR, we have always traditionally split transfer recordation taxes equally 50-50 unless the parties agree otherwise. So we maintain that 50-50 split. So we said any reduction in the state recordation tax resulting from the buyer's intended use of the property as a principal residence shall have the same allocation between the parties as provided above, which I'm going to talk about now, but generally that's 50-50. And it says, note in the event buyer is a first-time Maryland home buyer and elects to pay all state recordation tax and local county transfer tax, seller must still pay the non-waived portion of the state transfer tax. And I'll talk about that now with first-time home buyer. But it just clarifies that even if the buyer is, even if there's a credit on the state recordation tax, which is an exemption for the first 500 of the purchase price, the parties still essentially split that benefit 50-50 rather than the buyer getting the full benefit, which would cause some problems in calculating the transfer tax. But MR has done that in their contract.
So did MR do this? I think,
Yeah.
the MR did this because it was statutorily defined as being the buyer gets the entire benefit. Therefore, MR, Maryland Realtors, copied that in their document text.
Yeah.
We just do it a little bit different in GCAAR.
By practice,
By practice.
Yeah.
And that's the distinction. So when you're using the two forms, you need to be aware that that's where the difference comes into play when using GCAAR forms for those transactions versus using Maryland Realtors forms.
Absolutely.
Any questions there on that?
And another important point when using GCAAR versus MR forms for transfer taxes, MR now references the transfer and recordation tax split in the body of the contract rather than in an addendum. GCAAR still has it. We have it in the Montgomery County jurisdictional addendum. Okay, so just be aware that it's right in the body of the contract for MR. And then there's a separate Montgomery County jurisdictional addendum for GCAAR. Okay, just to make sure everyone understands though the language, since we're talking about transfer recordation taxes in GCAAR, this is again in the Montgomery County jurisdictional addendum. It's paragraph 3. You check off first whether the buyer is or is not a first-time Maryland home buyer. If not, it basically states section 14104B of the code provides that unless otherwise negotiated in the contract or provided by state or local law, the cost of any recordation tax or any state or local transfer tax shall be shared equally between buyer and seller. Okay, so equal. This is where the confusion sometimes lies, is if the buyer is a first-time home buyer, it mentions how you qualify for being a first-time home buyer, which is essentially buyers never, and it's never. There's some confusion on that. There are loan programs where after a few years it resets, but for the state transfer tax exemption, it's you can never have owned property in Maryland that you lived in as your principal residence. That's another source of confusion. Say you inherited a property from your parents who passed away, but you never lived in that property. You inherited it, owned it, but never lived there. You would still qualify for the first-time homebuyer credit, even though you own the property. You never lived in it as your primary residence. Same idea, if you inherited it, but then went to live in your parents' house that you inherited, then you would lose the first-time homebuyer credit, okay? And the second requirement, obviously, is the property will be occupied as the primary residence. The one exception there, you may be aware, is just if parents are co-signing a loan and not living in the property, the kid can still qualify for the first-time home buyer credit. Here's the confusing language. So if buyer is a first-time Maryland home buyer, under section 13203B of the code, the amount of state transfer tax due on the sale is reduced from 0.5% to 0.25% and paid by the seller. So state transfer tax is 0.5%. Right? If the buyer is a first-time Maryland home buyer, that's reduced to 0.25%, and that 0.25% is still paid by the seller. Nothing changes for the seller. They were going to pay 0.25% either way. The buyer's 0.25% essentially just goes away. And then in B, under 14104C, and this is again where it's confusing, the entire amount of recordation tax and local transfer tax shall be paid by the seller. So by statute, if it's a first-time home buyer, the statute still says that the seller pays all transfer and recordation taxes. And that's where there's some confusion, because it says, okay, well, by statute, seller pays. But no, we go on to say, unless there's an express written agreement stating otherwise, that's actually from the statute. But then we go ahead in GCAAR and state otherwise, right? Buyer and seller hereby expressly agree that payment of all recordation and local county transfer tax shall be shared equally between buyer and seller unless agreed otherwise. So we now default back to splitting equally, except for that state transfer tax, which just the seller pays unless you agree otherwise. So if you're going to agree to something other than splitting equally in a first-time home buyer situation, you would have to fill something in. Okay, so if you want the buyer to make a competitive offer where they're going to pay all the transfer and recordation tax, you would have to fill that in the blank in that paragraph. But it defaults to 50-50, even though the statute states that seller's paying all transfer recordation taxes.
So this is a little, so this gets really kind of confusing because we're back and forth between the statute, Maryland Realtors, and GCAAR's posture on it, and then whether or not you're going to revert back to what the statute says, you know, by writing it in. Is everybody really clear on as to what this really means with all of that confusing back and forth? I think there's an opportunity here for us to get lost in these weeds. Just wanted to make sure that everybody's clear on that. Speak now, forever hold your peace.
Or reach out with any questions. But yeah, now's a good time. Okay, no questions on that? Okay. One other recent update is on the radon requirement. So as you're hopefully aware, Montgomery County has the radon requirement, has had the radon requirement on sales, that a radon test be performed on sales of properties. Recently, Montgomery County added that radon requirement to leases as well. Okay, so that was as of actually July of last year. Montgomery County added the requirements that a radon test be performed for leases. There is now a new radon lease addendum. If anyone does rentals, if you've seen that form, you may be familiar with it. If not, reach out with any questions on it. I'm not going to go through the whole radon lease addendum, but there is one now for radon lease requirements.
And that does apply to townhouses as well. But it does not apply to condominiums. Is that correct?
Correct. Townhouses, it actually, well, it applies to condominiums if you're on the ground floor.
Correct, yeah.
Yeah, ground floor of a condo, it applies.
And I don't think we have any co-ops in Montgomery County, so that probably wouldn't be an issue. To my knowledge, we don't have any.
I don't think so. No, and I don't think it applies.
That wouldn't be an issue in Montgomery.
Right. Okay, so that's the radon requirement now for leases as well. One other point to mention, just while we're talking about radon for sales, more common, there is the radon requirement for testing, but just keep in mind, if radon is found, there's no automatic obligation for the seller to remediate the radon. Okay, you would think they would want to do something about it because now they're aware of the radon and they would have to disclose it if this contract falls through. But there's no automatic requirement obligation built in to the radon testing requirement. You have to do the separate radon contingency in the addendum of clauses if you want.
So that should be causing an aha moment in all of you, because, you know, so you've got the requirement to have the testing done for the new buyer. And let's say the test comes back and it's got, 10 picocures, right? And the standard is 4. Well, there's no requirement that mandates that the seller fix that. So if the buyer needs to have it addressed, then you have to execute that demand to the seller upon discovery.
Right. Separate. So if you're thinking the buyer wants a actual radon contingency, that is a separate paragraph that the parties have to agree to in the addendum of clauses.
Mel, did you have something?
Yeah, on the leasing, how often does the landlord have to do that? Does he have to do it between each tenant? Once a year? What?
For each new tenant.
Each new tenant.
Yeah.
Thank you.
And it must be no more than 3 years old for the new tenant.
Yeah. So that could be quite onerous.
Okay. It's all laid out in the GCAAR library in the radon lease addendum. So if you're doing rentals, take a look at that. The requirements are laid out there. Any questions, just feel free to reach out. I think my contact information is in here, but we can make sure you have it.
And we'll send that out to everybody. Kathy, did you have something?
Yeah, just for clarity. So if radon's found to be at the elevated level and seller is not induced to cure that, i.e., as you said, it's negotiation. The buyer knows the fact, tells the fact to the seller says, I'm not going to fix it. And the buyer does want to get out of the contract, and they do, because we've, documented everything correctly. Now it becomes a fact that the seller has to disclose to the new buyer when a new contract or offer is presented and ratified. So then why would a seller, what would be the incentive other than to try to, once known and disclosed, to capture a buyer who doesn't mind paying for that remediation? Is there anything that would be another reason? Because I don't think that, I guess in a competitive market, maybe second buyer would desire to get the house and say, fine, I'll pay for the remediation. But it doesn't seem to me, that the seller, would want that liability not to fix it. So I'm just kind of bouncing that around, and maybe you could make a comment about that.
No, I fully agree with your analysis there. I think the point is more that it just gives the buyer more of an avenue for negotiation if you include the contingency versus not including it, right? I mean, like you said, it gives the seller the potential out. They would have to disclose to a new buyer, but if they have another buyer in waiting that is a better offer, that they think that buyer would come in with a higher offer and just pay for the remediation, then the opportunity for that seller is there. But if you have the contingency built in, there's that built-in negotiation in the contingency.
So if we if our buyer, if we write the contract, we ratify the contract, there is no radon contingency built in, but it's discovered.
Yep.
It's discovered and disclosed prior to settlement. There is no waiver. There is no right to back out to void the contract.
There is no right. That's correct. There's no right based on radon alone. If you still have other contingencies in play, if it's part of the home inspection contingency, for example, then you would have that out. But you do not have an out just because radon's found, unless the radon contingency is included.
So that should be another aha, right?
Yeah. Any comment on how that's going to interfere with the loan process? If there's radon discovered, seller says, I'm not going to fix it. Buyer says, I'm going to continue, or buyer doesn't have that contingency, but then it's discovered. I know that clearly we don't typically share our home inspection results with our lenders, but is this going to be something that a lender's now going to require, again, knowledge of whether the radon has passed or not, based on, them clearly giving the loan on the property?
Sure. It's a good question. I'm not positive from a lender perspective whether that would cause any issues in the underwriting. Certainly, though, if there is a financing contingency in place and the lender rejects financing for any reason, including radon, then that would still give the buyer the out if the loan is rejected under the financing contingency. But I'm not positive from a lending perspective whether that would have an effect or not.
Do you think that a buyer could intentionally sabotage the deal by disclosing that radon level to the lender, and therefore activating the void opportunity within the financing contingency?
So yeah, I mean, hypothetically, yes. Whether there are ethical issues there, is a question. But from a legal perspective, I think they hypothetically could do it.
Yeah, good point. Good point.
Yeah, that's kind of what I'm thinking. I'm thinking, once lender gets involved with changes like these, especially with the serious nature of radon, can cause death. So, then you've got tie-ins with the mortgage and, all sorts of things that I can just see this opening a can of worms in the dialogue sense of what could happen with this information having to be disseminated against, or not against, but involving others than just buyer and seller.
Absolutely.
Yeah.
I think the point is, if radon's found and the contingency is not built in, it just gives the seller more leverage to say, well, there's the radon, but you can remediate it as soon as settlement occurs. You can put in a remediation device, and the seller could just say, that's what your right is at this
Yeah.
point, versus including the contingency where there's not that negotiation process built in.
And for most houses, a remediation system costs $2,000, $2,500 for most houses anyway, so.
Okay. Any other questions on that, on radon? That is all I have for the updates, for GCAAR updates. Like I said, we'll certainly have some more, we think, some more major ones coming out in July, so maybe we'll see you again then for those, but I
So,
think Dan
yeah,
had
so
something else.
we've got a couple of other things for you, some things that are really important for you to know. Let me go ahead and share my screen real quick, and I'm gonna go through this. As some of you know, I'm also an instructor for GCAAR, and I do teach GCAAR classes as well. Oh, come on now, don't do this to me. So I'm teaching on this Thursday, I'm teaching the legislative update class. Is this not working? And there's some provisions that we need to understand within DC specifically. So this is the DC legislative update. I'm just going to work with this. It's not working the way I want it to, but just bear with me. There's a couple of new laws that took effect March 1st of last year. There's a new tenant screening requirement. And let me make this a little bit bigger. So the tenant screening requirements in DC, and Noah, please jump in on this. Correct me if there's anything that you see wrong here, but prior to requesting information or fees of an applicant, we are required to disclose, number one, the amount of the fees of the security deposit. So we have to disclose this in writing to the prospective tenant prior to their application or prior to asking them any personal private information about their finances or qualifications. We've got to disclose how much the application fee is and what the deposits are and whether or not those are refundable. Number two, we've got to disclose to them the type of information that will be used to conduct the screening. Are we using a credit check? Are we looking at credit scores? Are we looking at credit references, employment? What are we looking at? We also have to disclose the specific criteria that will be used to deny the application. And we have to apply any additional criteria, disclose any additional criteria that may cause denial. So have you had a chance to review this law,
Yeah,
Noah?
that's exactly right. Yeah, that's right from the code in DC. Those are the requirements.
Dan, I have a question on that. Is this for property managers or owners? Because we as realtors don't have any decision criteria. Like it says criteria to deny, but we're not making a decision. That owners of the property are, or a property. So property managers might have to follow this, but what if we just list a property for rent?
So this is a housing provider requirement. It's not a requirement for you. So what's the
You mean, the housing provider, meaning the owner of the house?
Yeah.
Yes. Now keep in mind though, we kind of get grouped into this when we are listing the property for rent. If we're going to be listing the property for rent without having a management agreement, without having a property management agreement tied to it, and we are vetting those tenants for the purpose of satisfying the landlord, and let's say we're using Rent Spree, for example. And so ultimately the landlord's going to make the decision on whether or not to accept that person, but it's our job to advise our landlords of these laws and these requirements. And if we don't disclose that to our landlords, do you think, Noah, that we would have some liability there?
Not sure. I think it's built into listing agreements that it limits the liability, but it's certainly something you want to advise clients, whether there's liability or not. You want to make sure they're aware of the requirements, but these are just mainly disclosure requirements that we're talking about here.
Right. So now taking this to the next step, there's a couple of more provisions in this law. So prior to requesting information or fees of a prospective licensee, a requirement to disclose the name of the consumer credit reporting agency that will be used. So if you're using Rent Spree, I think they use TransUnion. So we actually have to disclose to the tenant that the TransUnion will be the credit reporting agency that will be used. If it's a different service provider that you're using, you need to provide that name of that credit bureau that will be used there. We also have to provide a statement of the tenant's right to get a free copy of that report, of that credit report, if they are denied. We also have to provide a statement of when the application will be approved or denied. So you've got to be able to tell them, and probably put this in the MLS or in your view documents, that the applications will be approved within X number of days after application submission. And correct me if I'm wrong on any of this, Noah.
All sounds right.
Yeah, we also have to provide a statement in writing of the applicant's right to dispute the findings of the credit report. So we've got to be able to provide that statement to say that they can dispute those findings. And there's two more provisions that we have to provide a statement in writing of the applicant's right to a refund on any unused application fee. And currently the application fee in DC is $50. So if your Rent Spree application is $49.99, I think that's what it is. You've got a penny left over. Technically, we're supposed to be delivering that penny back to the applicant. If you're using another service that costs less, then obviously whatever the balance is, you're turning that back over to them. And finally, the applicant may file a complaint with the Office of Human Rights or pursue civil action in court if they feel that you have made a decision based on the criteria incorrectly. So this really, I think this is a really, I mean, DC was already a very hostile environment for landlords. I think this exponentially makes it even more hostile. And because of that last one in particular, it really brings it to the forefront of the tenant's mind that they can file a civil action against the landlord if they feel like and really hold them hostage. So that could potentially tie your landlords up in litigation for quite some time if this scenario rolls through. So we have to be very, very careful about how we're going to deny any tenants to make sure that we are complying with the law.
Is there a form or anything that helps our owners guide them through this disclosure?
Yes, there is. There is a form that's in Zip Forms, and it is called the Housing Provider. It's in the GCAAR library. It's called the Housing Providers Information Sheet, I think.
Guidebook, yeah.
Something like that.
So is it a fill-in form? I can fill in TransUnion, I can fill in $50, I can fill in credit score, background check.
At the moment, some of this information is not on that form. At the moment, and that's probably something that we on the forms committee are probably going to have to really address, because the law has requirements in it that are not stated in that current form, like those things that you just mentioned, Shafiq.
Yeah, so the challenge that I, as a building owner in DC, have, as well as our clients have, is these DC laws perpetually change. Like, the council makes a change for the benefit of a tenant, and the problem is these don't get rolled out to the public to know that these are actual laws now. And people have been caught by denying somebody without giving them the criteria in advance, and then they go to to sue at fair housing or whatever. I can't remember the name of it. And it just is a waste of time and effort, as opposed to we just having a standard form that is just easy to fill out for our owners, or so that they are meeting the requirement of the law.
Yeah, and I think GCAAR is working on developing that form for us to expand it. So TBD on that.
Definitely working on the form. I hear you though on the difficulties with DC. It happens throughout DC government. We see it in the recording office and the tax office. They roll out updates without properly informing us in the industry, certainly not informing the public on a widespread basis. It definitely causes difficulties that are not easy to overcome. But on the GCAAR side, we can certainly come up with a form that addresses some of these issues. It's difficult to meet the real-time DC updates all the time.
Oh, and another provision about this that I missed on here is that in this law is that you cannot use the credit score as a deciding factor for rejection of the applicant. It can be a contributing factor, but it cannot be the deciding factor. You have anything to add on that?
I think that's right.
Yep.
Just to clarify, they can't just say that, okay, my requirement is this credit score of 700 and above. They
That
have to
is
say
correct.
it's 700 and above, plus confirmation of employment, plus prior housing conversations, or whatever the other criterias are. They would all have to be listed.
Yes to the majority of that, except for the fact that I would say that you cannot state that there's a credit score of X that needs to be there. Nowhere can you state a credit score of X.
I thought one of the provisions is to state what the threshold is.
Where are you getting that?
I thought from what was just read out.
No,
There are requirements to provide, all of these requirements that I've just spelled out here and that are
Yeah.
shown on the right-hand side of the screen. Those are requirements that are provided for in the statute. But one of the provisions is that you cannot require a specific credit score.
Okay.
So
Is it possible for you to circulate that statute for us in the most current form you have?
Yeah.
So that we have
yeah.
it?
Yes, I can circulate that. It is also a part of my class that I'm teaching on Thursday at GCAAR. But yes, absolutely.
Thank you, Dan.
Yep. Moving on, tenant screening. The maximum rental application fee is $50. Beginning January 1st, 2024, application fee may be increased above that $50 based on the consumer price index. There's a complicated formula that's used to calculate it. I don't want to get into that, but just know that the increases previously, the application fee was set at a statutory level. Now they've just moved to basing it on this consumer price index and a formula that's based on that. If a housing provider fails to conduct a screening of the applicant, the fee paid must be refunded back to the applicant within 14 days. So you've got your listing in the MLS. You've collected a number of applicants, and maybe you've got a couple of applicant fees. Maybe somebody has used Rent Spree and paid a fee to Rent Spree. Well, now it means that and you didn't actually. Well, actually, if it goes to Rent Spree and they've paid it, the application automatically gets run. So just know that if you're collecting money to run the application, you've got to run that application and come up with an approval or a denial. If you don't run the application, you've got to refund the fees, and you've got to probably be prepared to face some serious questions as to why you didn't run that application, because I think we've got some liability. You want to talk about that? Any liability that you might face with that?
Yeah. So if you don't run proper screening, are you talking about liability on the broker side or on the
broker and the agent?
Yeah. So you certainly want to be running the proper screening, or you could get the owner coming back to you,
or the tenant filing a complaint against us because here I submitted my application. You didn't even run my credit, but maybe you were discriminating against me because my name sounded like I was, Dan Bouchard, the French Canadian, and now I'm filing a complaint against you because you discriminated against me because I'm French Canadian.
So you always want to use objective measures, which are the screening process.
Yeah. And then finally, the DC screening, so housing provider may not disqualify the applicant solely based on a credit score. So that's what that is. And that's the location of this here. I'll send you these slides. I'll send these slides out to everybody just to make sure, and I'll probably put this out on a video, on a separate video as well, in a broker minute video. All right. Oh, and oh wait, we got one more here. Well, actually, there's one more thing here. So on tenant screening, if an adverse action is taken, meaning if you've denied the applicant, then you have to provide a written notice of the denial within the response date in advance. So remember back in a few slides back, we were talking about you need to provide the tenant with a written notice to say that an answer is going to be given to this application within X days. Well, that X days, you've got to get them a written notice of the denial within those X days. You also have to provide a written notice of the specific grounds for the denial. We denied your application because your reference turned out, somebody gave you a bad reference, or you had too many collections items, or you had, whatever. And keep in mind, what would your thoughts be, Noah, on denying somebody for collections items on health medical bills? Is there any distinction or weight carried on those?
If you're denying solely based on medical bills?
Yeah.
I think it depends. What scenario you're talking about exactly? So they're denying.
So everything else, the entire application looks great.
Yeah.
Fantastic. Everything
Yep.
looks beautiful, except for the fact that there's some collections for medical bills that, and we know how medical bills kind of are a separate kind of, they're weighted a little bit differently
Yeah.
in the credit reporting business. And so because they're weighted differently, they have less importance, and people have medical conditions that sometimes are monumental that end up getting into collections because they're just mathematically not able to do it.
Yeah, I would just say you always have to base denials on an objective criteria. You can't zone in on one specific item. It always has to be objective criteria.
Yeah. Number 3, we've got to give them a free copy of the credit report and any information obtained by any third party. So number 4, we've got to provide a statement of their right to dispute the accuracy and permissibility of the housing provider's decision. And number 5, a statement informing the applicant of their right to file a complaint with the Office of Human Rights. So those are serious considerations for a landlord to take.
Dan, let's say you used a background check, you used reference checks, you did a credit score, and the person had some bad references. The credit score wasn't very good. There was some delinquent payments, and you stated all of those. Does the tenant have the right to say, well, who was that reference? Who gave me that bad reference?
I don't think so.
Because what you said just right now is they have a right to ask.
Yeah, I don't know of anything in the statute that requires it, that requires you to disclose it. Who gave you the bad reference? Because I think that could go back to retribution, and I mean I think that there would be valid reasons why you would not want to do that. But I think simply
because it's also considered very vague to say you had some bad references.
It is, but I think that's, if that's
I still think that's the specific reason. It can be the reason itself you can keep vague, but it's still the specific reason for the denial is based on bad references. I don't think there's anything in the statute that would require you to disclose who those references are.
It may not be in the statute, but it may be in the consequence of what the tenant believes afterwards, saying, I want to know.
Anybody can sue anybody for any reason. Anybody can.
No, I understand. I just, for our landlords, what do we tell them if something
Yeah.
comes up like that?
I think the point of all of this content is to really advise, our landlords that there's really substantial risk in being a landlord in DC. That's the real point. It's not to tell them that they shouldn't do it, but they need to be aware of it.
Is, on the, denial, can you use another application in relation? Can you say the landlord chose an application that had a higher credit score and a higher income and better references?
I don't see why
I-
not.
I think as a
Um,
continue on.
yeah, I mean, I don't see why not. I don't know that you can share specific information from other applications.
Right.
I
But you
don't, I
put it
think
in
as a
relation to,
I think as a matter of practice, Mel, I think we should as a best practice in the industry, in order to avoid errors and omissions complaints against us, or issues that we might have to defend later on. I think it's wise particularly in DC, but it's probably wise everywhere, to receive your application, process it in full, make a full decision before accepting another one, and use those chronologically. Whoever was received chronologically, that's how you process them. If you use any kind of non-objective means to process an application, so let's say you've got the listing and suddenly you've got 4 different applicants and you start cherry picking them, I think we run into an opportunity for somebody to complain against discrimination on us based on that. If you base it solely on a first come first serve basis, you're removing yourself from the opportunity to be held liable from discrimination in that sense, and you're not using one other applicant as a weapon against this first applicant.
all right, makes sense.
Yeah, I mean, I would say this.
Looking
I'm
for
not.
another way to be vague.
Yeah, yeah. I would say this. I'm not specifically a DC landlord tenant attorney. If you or the landlord or the owner has specific concerns or even general concerns about some of these issues, about some of the statutes that are difficult to interpret, we certainly have, and you may have as well, DC landlord tenant attorneys that or we can refer one that could answer some of these specific questions, maybe even better than me. Because these DC landlord tenant laws are heavily slanted towards the tenant. The landlords definitely want to be careful with them. And I would want an expert who we know a couple of, that when we have questions on DC landlord tenant law, we reach out to. So if you ever need a referral for that, we know some attorneys in DC that specialize in this type of work.
Any other questions for anybody on anything on this topic, these topics? Tony was awfully quiet. And I don't know who iPhone is. Anyways. All right, everybody. Go ahead, Tony.
No, I thought it was a good class. I drank it in, and I do a good amount of work in DC. So sure, I'm always warning people who want to rent their homes or condos or buildings that it's very tenant friendly. So try to walk a straight line. And there's so many laws, you're probably gonna not execute everything to the letter of the law. As we said, it changes all the time. It's so one-sided, sometimes very illogical. But I really enjoyed the class. Thank you.
Great. Thanks, everybody, and we'll
Right.
send out some material later on.
Thanks a lot, everyone.
Take care.
Thank you.
Yep.
Bye.
Bye.